What key factors should clients consider when evaluating the fairness of the services they receive?
So the primary two from the client's perspective are the amount in dispute. Are you dealing with a $50,000 issue or a $10 million issue? That's key on what they should be expecting from their lawyers. The second issue is, the second factor is, what is the actual goal? Sometimes it's not to win the lawsuit. There might be some other goal. So ensuring that the lawyer is working towards that goal rather than some other goal is also key to determining the fairness. And then you have to look at, what is the lawyer actually billing you? If it's a simple issue that's a $50,000 issue, you should not have a lawyer with 30 years experience charging you $1,000 an hour on that matter. So there has to be communication between the client and the lawyer about expectations. And then the final two, which kind of provide the entire context of whether the legal services were fair, is the value added. Were things being moved forward? Was excessive money being spent on just communications? Because communications don't really get you anywhere. So there's that, and then that's linked into what was the actual result? Was the goal achieved? And when you take account of the entire nexus, what you're expecting, the amount of issue, who was dealing with your matter, the billing practices, do you feel like you got value for the money you spent?
How important is transparency in legal fees?
It's fundamental from both the client's perspective and the law firm perspective as well. Most of the issues that we deal with when we're assessing accounts comes from an upset client because they don't understand what they paid for. And that goes the other way, is law firms are wondering why they're not being paid. And generally it's the transparency in the fees. And you can see some billing practices, for example, accounts are issued and it's just a block. It says 50 hours, $10,000. And there's no explanation of what the 50 hours was, who worked, who did the 50 hours. And so when you see things like that, that causes issues between the law firm and the client. And so transparency in what the client is paying for is key.
What are the different fee structures commonly used by law firms?
So depending on what the services that the law firm are providing, they generally have different fee structures. If you're getting a will drafted, it might be a set fee of $1,500 or something around there. If you're in litigations, tax court litigation, it's probably going to be an hourly retainer. And that's simply because the law firm doesn't know what the other side is going to do as an adversarial process. So the other side might be bringing motions and doing all these aggressive maneuvers. And if that law firm had set a fixed fee, it's actually going to be losing money by working under one of those fixed fee arrangements. The other fee is a contingency fee, and that's generally what you see in personal injury. And that's because you've got to take account of who the client is. So people getting hurt, they might be a WSIB worker. They might not have the resources just to pay a lawyer $10,000 to litigate something for themselves. And so these lawyers recognize that. And so they take on the risk of doing the litigation for free. And that's where a contingency fee comes.
If clients believe they have been overcharged or received unfair service, what steps can they take to address the issue?
So firstly, their lawyer is supposed to advise them of a process under the Solicitors Act. It's called an assessment process, where the lawyer's bills and accounts will be reviewed by the court, and what the court determines is reasonable as between the lawyer and the client will become what is payable. It basically turns the account into an order after the court has reviewed it. And that process is client-facing. It's supposed to be very easy. Clients are supposed to be able to do it by themselves. And it takes account of the fact that lawyers are officers of the court. And so the court has the ultimate determination of what fair and reasonable fees between the lawyer and the client would be. And so lawyers are supposed to be advising their clients of that process. There are very short time frames, and there's quite a lot of litigation over missed deadlines on bringing those applications. Best response is to retain a lawyer such as ourselves that specialize in the assessment of lawyers' accounts, and we'll be able to look at your circumstance, ensure you're within the time limits. If you're outside of the time limits, we can advise you on the various routes that you have to take through the court in order to get yourself into the assessment process.
To finish, what are your top 3 tips for clients to ensure they receive fair legal services?
My number one tip is communicate with your lawyer. Tell them what you're expecting. What is the result you're expecting achieved? Let them tell you what they are trying to achieve. And that communication will actually ensure that what you want is occurring. Sometimes clients don't make that clear, and that's just a recipe for expectations not to have been met. So that's number one. Number two is ensure there aren't four lawyers billing on your file. You can have a very complex matter, or you can have a simple matter, and depending on the complexity or the amount at issue, there might be various lawyers billing on your file. Make sure you're reviewing that. Make sure there aren't double bills. For example, one lawyer might draft a letter, and then there'll be another charge from another lawyer for reviewing that same letter. That's kind of, in my view, that's overcharging. So ensure that there aren't practices like that going on, because those can rapidly increase the fees that you're paying and undermine what the client is expecting for the money that they're paying. And then in the same ilk, review what's being done. When you get that account showing, $5,000 of work being done on your file, look at the work being done. It should be all set out. Is it all going to communications, or is actual work being done? Are court documents being drafted and filed? The bill should highlight exactly the work being done. And if it's all communications and no work product, I would start raising those concerns early on and right away. By doing that, you're advising and telling the lawyer that is working with you that you're reviewing his bills and you're ensuring that this is proceeding in the way that you're expecting.